Good afternoon, everyone. Welcome to our expert webinar for May. I'll give everyone just a couple of minutes, either to settle themselves down if you're already logged in, or to log in if they're coming off of other meetings. So yeah, we'll probably start our webinar at about 12:03. You'll be able to read, obviously, some of the logistics on the screen here on the slide that you'll see. But if you've got any questions, please don't hesitate to ask them in the Q&A at any point during the presentation. We will come to those questions at the end during the Q&A section. If you need to jump off at any time, you'll be able to rewatch the webinar using the same link that you joined with today, and you'll also be able to see any of the resources on our resources site post this webinar. So yeah, I'll give everyone just another 2 minutes to join, and then we'll kick straight off. Fantastic. So we've just seen the last couple of people filter in, and anyone that filters in now will also be able to watch this, as I said, on demand as well. So in terms of the logistics for the platform, as you'll be able to see, you have a Q&A section on your screen. You'll be able to ask any questions during the presentation. You're also able to resize any of the panels. So should you want to resize the video panel, you can redo that. You're also able to resize the slides if you'd like to see those a little bigger as well. You're also able to then view any of the resources on our resources page. So on our website, we have a news and resources page that you're able to see any of the resources that are related to this webinar, but also any of our resources and case studies from previous webinars as well. So without further ado, I will now hand over to Martin Holsworth of IDR Law. He'll do a much better job of introducing himself than I will, but he'll be talking today over the realities of running contentious probate work. So Martin, welcome.
Thank you. It's very kind of you to have me. Afternoon, everybody. I hope everybody is well. I'm coming from a very wet and quite miserable, actually, North Yorkshire, but we have been enjoying some sunshine. I thought I would today take you through a kind of an observational kind of sharing, or trauma dumping, as perhaps my kids would say, about contentious probate work, my experiences of dealing with it, what I think might be some helpful nuggets of information for those that actually do it, those thinking about doing it, those thinking about doing a bit more of it, and even those that are going to want to go anywhere near it, and where do I put it if I do come across it. So it is an observational piece. If you do have any questions, then please do fire them into the Q&A, as Phil says, and I will take it fairly steady. Starting with, I can see the guest list, that there's a few people I know in there, but there are quite a few people I've not met before. So those people who do know me, please forgive me. I'm going to run through a little bit of my background, and that hopefully will provide you with some form of start point to understand where I'm coming from. I've just realized that photo is way bigger than it should have been, but anyway, That's me, top left. I am a solicitor. I've been doing contentious probate work since, I think my first one was a trainee solicitor. I was in the last year of article clerks, if I'm completely honest, but trainee solicitor in 1993. I have been on the Act Apps committee for, I think, 8 years now. Chambers, Band 1, Legal 500, Hall of Flame, and so on and so forth in terms of doing this type of work. So I've pretty much seen it all over the last 20 years. I've certainly developed and grown teams within big firms. I've grown them in small firms. And then in the autumn of 2017, I launched IDR Law, stands for Inheritance Dispute Resolution Law. Did that with an empty cabinet, lots of excitement, but a strong B2B network of referrers. The last 6.5 years, we've enjoyed aggressive but controlled growth most of the time. We have a current headcount of 23, and that 23 includes 17 contentious probate lawyers who are at various levels from partner down to paralegal. We have a referrer network and a client base that's nationwide, offices in Manchester, Bristol, and HQ is about 12 miles away from where I'm sat in Harrogate. Last 7 years, we've dealt with I think the last count was 7,227 contentious probate inquiries. So we are pretty well placed to not just deal with inheritance disputes, but also see patterns, see the things that come along, the types of problems that people are facing and seeking help, and then hopefully not just resolving the problems that we get engaged with, but help people also avoid them. My 5-year mark in the business was fairly pivotal. We got to a stage, and I will deal with this in my talk about the size of the firm and the nature of it and the needs of cash and the rest of it when you're running a practice, where I had a decision to make. And the decision was either to push on with a lifestyle business, I think they call it, but I decided that no, I wanted to grow it. I think there was an opportunity in the market was there to do it. Explored bank funding, debt funding, and so on. And in the end, decided to accept a minority investment from a private equity house, BGF, with a brief to grow the firm ×3 over the next 4 years. So we're going to be very busy. Feels a very grown-up firm now, with chairman and FD and exec management team, growth shares, all the rest of it. And I'm busy trying to learn to be a CEO rather than a founder, which is not always as easy as it sounds. At the time of the deal, we had another company, the sister company that ran alongside it called Matrona Technologies. And in there, we developed, my background's maths, physics, computer science, so I'm quite techie by nature, and we were developing some resources that we thought might be useful in our sector, both in terms of avoiding problems, but also lead generation type work. And when the deal went through almost a year ago now, that was brought into the kind of fold, if you like. So that's me. So give you some idea of my depth and length of time in this particular sector and why I feel like hopefully I've got 1 or 2 things to share with you. First things first, if anybody's got a contentious probate team or first started working in contentious probate, one of the first things that actually you come across, and it's silly, but it is something that crops up, and I don't think anybody's nailed it yet actually, is what on earth do we call ourselves? You know, what should the department be called? Contentious probate is how we in the legal profession refer to it. But if you look around various teams, various firms, various people doing it, you'll see the whole gambit of different titles describing what they think contentious probate is. So it could simply be contentious probate, contentious trust and estates, private wealth disputes, private client litigation, contentious wills, trust and estates, or simply, as we decided to do, is just call it inheritance dispute resolution. It's all in a name, but then there are 2 things that I would say about that. One is that in terms of finding us, and I'll talk about how people find us, is search terms, SEO. You know, what are people, none of those words really are language that people actually use in real life. No one sees a will and says, I'm going to take a private wealth dispute about this. They say, I want to compete, I want to challenge this will. So you'll find the SEOing and the terms of this type of work are always very, very different to what we describe ourselves as. And I think the other reason for that is that lawyers pop up into contentious probate from different sort of source departments, if you like. And I say that from personal experience, is that my first couple of years of qualification was actually as a divorce lawyer. And I enjoyed helping people get through what is a fairly difficult family set of facts and emotions, but then realized that I enjoyed the commerciality of litigation. So I moved into litigation, and I sort of look back and can now see that it makes a lot of sense, is that contentious probate does in fact sit between family law, wills and probate in its traditional sense, and litigation. So it sits literally right in the middle of that. And I remember joining a very big firm in 2007 and then not knowing where to sit me. You know, there was so much debate about, do you sit in litigation? Do you sit in the wills and probate team? And me being me, I sort of said, I don't care where I sit, as long as I've got access to those people who can refer me some work. So I sat in the wills and probate department. But you can see how it's always a little bit confusing as to where they should sit. I think most good contentious probate lawyers will have a little bit of all of that. They'll have the ability to deal with families in distress. They'll have the ability to understand wills and probate work, and they'll have the ability to understand that it is at its core litigation, different type of litigation, but nevertheless still litigation. So it starts with a little bit of a confusion, and then it starts to grow. And perhaps we'll find some answers in terms of the types of contentious probate dispute that we deal with. And insofar as that's concerned, is that for me, I think the four main types of dispute that we look at are probate claims, basically challenging the will as you know, so we don't like it, we're going to try and knock it out, or we're going to defend it. You'd be amazed how many times we see claims being brought where they haven't actually considered what the results of that being successful is, but nevertheless, that's the claim. We then move down almost on a hierarchy to some extent onto Inheritance Act's 1975 Act claims, where there's a suggestion that whether there's a will or isn't a will, reasonable financial provision hasn't been brought. You're then down to equity claims, where you're talking about admin, lifetime disputes, a smorgasbord really of all kinds of horrible stuff that's in there. And then we get spin-off litigation. So that can be professional negligence, cohabitee property disputes, tax disputes, charitable legacy disputes. So contentious probate itself is niche. There's no doubt about it. It is very niche, but it's deep, and it has offshoots that go off. And this is worth bearing in mind when looking to expand a team or even start a team doing contentious probate, because you are going to get those problems popping up. Now, for me, what we decided to do is that I wanted to stick to what I knew best, which was contentious probate. So we made a decision very early on that anything that spun out, we wouldn't do. And we developed really good relationships with other law firms, invariably boutique practices as well, who would pick up the prof neg, the cohabitee property disputes, or the tax disputes. If you're based in a firm that's got departments, then you will find that you can pass those across. And for anybody who is within a bigger firm, so you're one department within maybe several, is what I would say to you is, and I did this religiously, is to track the referrals going out of your department, because there'll be conveyancing as well when you get the situation resolved. There may well be a state administration at the end of it because you've resolved the problem. Keep a track of what's going out to the rest of the people in your firm, because if you do that, and I've been doing this for probably 15 years now, is that you begin to see your value and your value to the practice, and you'll be amazed how much more work is being sent out from yours to others. But you have to track that. You have to make sure that that actually rests in your paper when you're going back to report on your monthly results of your team, or indeed a quarterly review meeting. So I would remember to do that. Why would anybody want to do contentious probate? What's the pull? I mean, for me, it was about problem solving. It was about the knowledge of the law surrounding contentious probate is almost, I won't say secondary, yeah, but you have to know it. But once you know it, it's a framework, and it's a framework for the rules of engagement with your opponent, for dealing with your client, to find some kind of solution to the familial problem that's in front of you. The law will give you the indication as to where you want to go with a claim. Can I change this? Can I take an action? but for those people who do contentious probate, you'll know, is that solutions invariably are far more wide-ranging, preferably, than merely getting a ruling on a specific point. Knocking out a will, obviously, is an obvious exception to that, but in the vast majority of cases, it's a bigger picture. You pull a string and it pulls in other areas that you want to be able to do it. It's heavy work, but it's rewarding. So from my point of view, I've never had a day where I've thought, I never want to do that. Actually, it's a lie. I have had those days. Not many of those days. It is one where you can come home and feel like you've made a contribution, you've made some kind of benefit to your clients, and maybe even your referrers if you can. The problem with it, of course, is that you can't rest on your laurels, and anybody setting out in contentious probate or does it should know and will know that you can't either cut corners or provide poor service, because your clients are already grieving. So if they don't feel like they've been cared for or looked after, and I haven't mentioned law there, it's just about the care and looking after them, then they are absolutely ticking time bombs of angry clients. So if you don't build your team in a way that enables you to service the clients properly, then your complaints will just go up. It's an absolute guaranteed fact, is that the number of complaints that you will get will go up, and they will be difficult to be resolved, because invariably what the clients are doing is transferring their grief and their anger for what's going on, and suddenly there's somebody that we can now actually talk to. So that is you, and this is why, A, it's great enjoyment, you can make a difference, but you should never, I mean, my personal view, we don't have anybody on a maximum or more than the maximum 25 live cases for a full-time lawyer. So don't know how that compares to anybody else out there, but 25 cases is our view as to where we should be with this. And that's really where I'm coming from to some extent, is that it's about getting a balance between doing the right job and the commercial realities of running a team. In terms of the commercial realities of doing contentious probate work, is that there are very, very few people you will speak to who will tell you that they think contentious probate is declining. Very few. Most will tell you that they think it's going up. Most will tell you that the number of issued court cases down London has gone up almost year on year. Most will tell you they're busier than ever. I think the reality is that the perfect storm that started probably 10 years ago is still blowing strong. I think it will continue to blow for at least, in my view, at least another 10 years. We've got estates, most of these facts you'll know, but it's worth bringing them together. Estate value is higher in history. Blended families, as the Americans call it, so two sets of children from first marriages coming into one. We've got an aging population. We've got 60% plus of no wills being made by people. And then we've got intestacy rules that don't even acknowledge that cohabitation is a thing. Society is more litigious, that's for sure. And 1.3 trillion, or whatever the most recent figure is, are likely to pass from the oldest generation, which is the wealthiest in history, in the next 10 years to the generation below. So all of those things you will have seen, read, heard, and experienced yourself. The one thing I wanted to share you with this is that in my own experience, there's a new one, and this has crept in over the last 5 years. And there's been a couple of reports on this and surveys. And one such survey from a large insurance company showed that of all the people that they canvassed, 1 in 3 were relying on an inheritance to either fund retirement or discharge debt. So that's 1 in 3 relying, not hoping, not expecting, not even sort of spending. They're actually relying on that money coming through. And of course, if you're relying on something that you don't then receive, more often than not, you need to do something about it. And doing something about it simply means coming to see somebody like myself to see if you can change the effects of the will or the intestacy. And I think that's become more and more apparent as we've gone on. I remember receiving a claim letter, probably thick end of 15, nearly 20 years ago now. And it was the first time I'd ever seen the attempt by an opponent to argue that in reliance of an inheritance, that they had acted in a certain way to their detriment and as a result, a loss was suffered. I'm not talking about the traditional farming type cases. This was two sisters, and one of the sisters had relied on an inheritance coming through from parents, and parents had an estate of 3 million back in the day, and they gave it all to a charity. And she brought a claim on the grounds that effectively she was expecting this money to arrive, and in reliance of that, she had lived her life accordingly. So she had spent and was now in trouble because she didn't have a plan B. And I remember reading the letter. It was from a well-known large law firm in London. And it was about 12 pages long, and I was laughing probably for the first 4 or 5 pages as I was reading it, thinking this is ridiculous. But then by the time I got to page 7, 8, and 9, I was sort of not laughing anymore. And I was thinking, my goodness me, I can see how this is going to be a direction of travel. And so it has proven to be, as I think people live those lives. And I think that's the explanation more often than not as to why they're coming in to see you. So that tells you, in a short, yes, there's going to be more claims. Yes, it's an area that is going to be busy for at least another decade and beyond, or at least until the estate values at the top pass to the next generation. So that leaves opportunity, because where there's some things happening of that nature and it fits into the type of work that you do, then you will get law firms and lawyers looking at that and saying, well, that will be a good idea. Why don't we get involved in that type of work? We can assist and we can make commercial fees on the back of it. So do you, and to some extent, there's a decision then to make, isn't there? Is that if as a law firm you already do it, and I can see some of the names of the people on this call who are contentious probate lawyers already, is that if you already do it, you may even have a team, is do I carry on and expand? If I don't deal with contentious probate, do I start? And if so, how do I start? Or you may be an estate administration company that decides that I need to build some kind of relationship function that means that I can monetize the exposure I'm getting to these types of claims coming in. So you will find that those choices are being made every day. And talking through those, my own view, sharing again, is there are really 3 main sources of contentious probate work in my experience. The first is internal referrals from within your own firm. So if you've got a multidisciplinary practice, or even a practice that just does private client work, there's not many of those around, that also have a contentious one, but if they have just private client work, then again, that's the source of work that you will get work coming through, and you will get it. You know, I have started and built up to a team of 9, basically on the back of feeding off a 25-strong private client team, together with a network of anybody else within the firm representing clients. And I used to walk the floors to do that, because lawyers are terrible at cross-referring, as you're probably aware. So I used to literally I tread around looking for work, and it worked. So you will find that with internal referrals, that's the most obvious source of getting some work getting through. Don't assume that people will pass it to you. There's nothing better than standing over their shoulder saying, how are you? Have you got any problems at the moment? And 9 times out of 10, there will be, oh, I'm glad I've got you. Let me talk about this. And before you know, you're walking away with a file back in the day before it was paperless. So definitely worthwhile doing. And there are lots of teams. In fact, I'd say the majority of teams that are out there that are 2 or 3 strong tend to be feeding off good quality internal referrals. There's then the second source of work, which is the D2C, or the direct to consumer route. So those are people who are in need already, consumers, clients, who want help, need help, and they will come direct to the person that they think they will get that help from. So the source of that is out there. So it's not within, it's without, and you need to get out there, and you need to become visible, you need to be seen, and bring that in. And I'll come back to that a little bit later. Third type is B2B to C, which is obviously business to consumer. So what you've got is relationships, I call them referrers, with referrers in our sector who are already looking after clients who then become aware of a problem, dispute within the contentious probate arena. They will then refer it on to you. I'll come back to some of the problems that can bring sometimes, and why it has some limitations. So effectively, those are the 3 that we have. Most people have a combination of those 3. The vast majority of contentious probate teams will be doing the first two, which is internal referrals, direct to consumer, and a little bit of B2B. The thing to remember about the actual market that we're actually going into here, and I agree, we can see a growing pool of problems, but where's the scale? You know, how do we, how much is that? How many are there out there? Everybody seems to be looking at it. How many are there? And there's no real hard data, but anecdotally, what I would say is that if we've got circa 500,000 deaths a year going on, and of that, we've got 150,000 thereabouts grants of probate or less of administration that have been sort of second death they're going through. You've got 150,000 grants. We know that the biggest player in the market in terms of dealing with probate estate administration is the co-op. So the co-op will deal with anywhere between 7,000 and 8,000 grants a year. And then the next one down is about 2,000 grants a year, and then it drops again, and it drops and it goes down. And what you end up with is almost a logarithmic sort of graph of sources of estate administration work. So if you can imagine it sort of disappearing down and getting thinner and thinner and thinner, is that the number of organisations dealing with estate administrations is enormous. And there aren't any massive rich veins other than sort of the first probably 10 on that list that have volumes of estate administration. Why is that important? Well, what you will find is that, and again in our experience, is that when I first started, it was 5% of estate administration would experience some kind of problem that would need me or the team to get involved in. So there will be, it's almost like a crime watch warning, isn't it? Is that there's only 5% of estates that cause problems. I think that's on the rise, and that's the number. I don't think it's reached 10 yet, but I think, and this is based on data, but it's about 7 or 8% of all estates have some kind of dispute. So if you do 100 estate administrations a year and you're tapping into that B2B market, then you know they're probably going to have about 7 or 8 of those will be disputes, and you would hope that they would then refer that through to you. So you can see long logarithmic targeting, marketing strategy. There's actually needs to be really clever to reach them at the right time, at the right moment. And you've only got between 5 and 10% of those that are actually going to turn into problems. Good news is of course that from a commercial new business point of view, is that whilst that might well be true, is that unlike most litigation, is that you will find that there is usually at least 3 parties involved, and invariably there may well be more. It's not unusual to have 4, 5, 6. So whilst you might have X number of disputes, you can times that by 2, 3, 4, even 5 to get the number of clients that are out there that need help in relation to those sort of 15,000 disputes a year, or whatever that figure is. So you can see that whilst it is growing, it is busy, the actual barrel is actually not deep, but it's very, very wide. So shooting into that barrel brings its own challenges. Moving on to that, the challenges I've got listed down there, some bullet points and some summaries. And starting from the top, the challenges of contentious probate generally is it's the distressed sell, you know, and like all distressed sells, they're actually quite difficult to sell. There's a reason why there is no sort of hearse chasing type adverts on television. You know, have you been missed out? Bring a claim here, there, and everywhere. You can't. And of course, the thing about distressed sells is that the way in which they're broken down is that you want to sell a solution. We're really good at resolving this probate dispute, but of course you need to educate first. You actually have to sell the problem before you then provide them with details of what your solution is. And that's quite a long time in advertising terms, is that you've got to explain all this, run through it, you've lost them already. So actually it's about education for us, is that we work really hard on educating those who are out there talking to the clients and the families that may need it. So it's to try and educate them to spot when is an opportunity for us to actually step in and make a difference. So Distress selling is difficult to do. It's not impossible, but that's where, you know, face into it and actually try and do that in a different way. There's also internal competition. So again, this sounds daft, but it's real. And for those contentious probates on the call that have been doing it for 10 years plus, I'd be amazed if you're not nodding as I say this, is that when you first start to look at doing contentious probate, invariably there's more than one person that's quite interested. I already made the reference to the fact there was 3 departments. There's the wills and probate, there is the litigation, there's a family department, is that you'll find people popping up doing little bits of it, and then there becomes a little bit of a competition as to who should do it. There's tensions. Lawyers don't cross-refer too well at the best of times. And actually trying to force that through can sometimes be a problem. My own view is it needs somebody who is dedicated to just doing it. I mean, I would say that, of course, because that's how we built our practice. But in my view, it is a specialised subject, not just because you're bright people that can do other types of disputes. I've done other types of disputes, but it's more about the mindset and the freedom to be able to say, I don't do anything else, I'm just doing this. You need a leader, and a leader needs to take it and run it. It will not run within your firm if you've got 2 people who are in different departments with different marketing budgets, different angles, different skill sets, different legal knowledge. It needs to be a commitment to do it there and then. Again, this is a list of all the things that we've gone through, but the triaging and client service levels are constantly being reviewed. It's the one thing that I would say has changed and is I'm always feeling like we could do better, is that we've had 7,000 inquiries plus. So, and we average 21% conversion rate to live cases. So what I mean by that is that for every 100 phone calls coming in from people who believe they need some help, 21 of them will have the right combination of, yes, you do need our help, yes, you do have a claim and you're in time, and yes, it is commercially viable. So all of those things present means that we will take it on, and we very, very rarely lose cases that hit those criteria. We will bring them on, and 21% of them will turn into cases. What about the other 79%? They're all still distressed. They're all still upset. Invariably, they've been referred internally from other businesses. You want to make sure you look after them. We run an NPS scoring system that goes across the whole cohort, and we make sure that they become our sellers. So they go back to the referrers. In fact, most of the testimonials you'll see are from people who we've given them a steer. We listen to everybody. And the way we did that, well, the way we do it now, is that we have a full-time triage team. So we've got a head of triage, we've got a reporting mechanism in triage. We use tech to track the triage process from biz dev to contact, from contact to inquiry to triage through to case. And it's all, I won't say seamless, but we're getting there, is that it's all tracked. And that data really, really helps you understand. There aren't so many sweet spots, as I say, is because there's not big, rich veins of this type of dispute work, but you begin to see patterns, and that helps educate them where we're going. So service levels are really, really important. And I think to some extent, the other thing you've got to be careful about is when you do triaging within a team, who's going to be doing it at your firm? You won't have a dedicated triage team unless you've got a sizable practice. And it means that the contentious probate lawyers themselves will be doing it, or if they're a bit too busy, they'll ask somebody else to do it on reception, or however it's done, managing that in terms of making sure you get the good cases, but equally making sure that you're not burning through your chargeable hours on stuff that you're never going to get live and off the ground is the balance. And that's the learning curve that we took, and we got to where we are now. Getting past the internal max threshold, what I mean by that is I made reference before to there being internal referral of work, and that's a nice steady stream. Invariably, it's good quality work. Invariably, the conversion rate is almost 100% because they're asking you to get involved because we've got an issue. So it is a lovely stream of work, and it's one that I haven't enjoyed for many years now, but that was a decision I'll talk about a little bit later. But insofar as work coming through there, you can grow a team to 2 or 3 people potentially, even more actually. If you've got a big private client team, I managed to to get it up to 9 when I was at Gordon's, but you can do it at bigger firms, feeding off that internal cross-referral work. You'll top it up with a little bit of D2C and a little bit of B2B, but ultimately you will max out what you can do there without getting up, getting out, and starting to find that network, that long marketing. And it's hard work, which is why people don't do it, is you've got to put some time in. And the thing is, because only 5% of estates are disputed, or only 10%, is that you're not, the chances of you turning up and there being a case there right away are pretty slim. So you need to find a way of working that is successful and still enables you to do the job, do the fees, gather it in, do everything else that a growing team needs you to do. So getting past that max threshold is really difficult. And I did it when I set up my last team before IDR, and I did it because I kept all the data. I've got data going back for it, and it's just insights into where does the work come from, internal, external, and then track it. And I got to a stage where I realized that 70% of my work was now external, so I could now move on and make hay with that. And the reason why I made hay with it is because I decided that I was going to move away from non-contentious, because that was the big step to enable me then to get into the estate administration companies and various other non-contentious estate administrators who simply didn't want to refer to anybody who was competing with them or anybody who had a department that was competing with them. So it was, looking back, it was a bold step, but it's paid off, and we've been very aggressive in terms of growing that forward. You can do that. There's nothing to stop you doing that. I don't think there's another law firm out there at the moment that just does consented probate and nothing else, but that's not to say it's not possible at some stage of doing it, but just get your data right, track your data, work it out, and I'll talk about cash flows in a minute. D2C or B2B to C is really that point, is do we go down the SEO algorithm, PPC campaign route for the D2C? There's some big teams out there that do that, so sometimes they throw money at it, either work, other times they're just really good at the SEOing, and they manage the inflow, turning the tap on and off. Downside with it, as they will tell you, is that the quality of the work is not as good as you will normally get with B2B. There's never any repeat referral work. You can't build relationships up like you can with B2B, but you do get a system and do get stuff coming through. For us, IDR, we are 10% of our referrals come from a B2C campaign. We're changing that slightly, but only with tech to do some of the triaging. So it is, and as I say, there are firms out there that do very well at it, and it's difficult to manage. Go back to the triage point, is you're going to have to get lots of volumes in if you're only converting 9-10% of all of those. B2B is stronger. We think there are 7 channels of different types of business referrers, and we work very hard on our comms to make sure that we are talking in the right way to the bits that's important to them. That you can do. Anybody on this call who's doing potential private work, is that there's nothing to stop them developing those relationships and understanding where they're going to. Biggie is cash flows. I don't know if there's any FDs or managing partners sat on the call, but cash flows is, it's quite difficult, isn't it? From a contentious probate point of view, why is it difficult? Well, it's difficult because the vast majority of cases last at least a year, if not slightly longer. And particularly, there's not many disputes where you get to the end of them, and very often you've then got to wait for an asset to be sold or realised to release money to then pay you. So what you get is revenue going up quite quickly because you've got a team, expanding team, putting billable time down, not wanting to bill the case until they know they can get paid. They don't bill it, so it sits on the balance sheet as work in progress, taxed on extra corporation tax as well if it's non-contingent, and you'll end up then with a big pile of revenue that looks great. I've seen so many P&Ls that have been shown to me from teams doing contentious probate whose P&L looks great because you've got revenue at the top line, and then you've got profit on the bottom line, invariably at 30% plus. But as soon as you ask for the cash, can I see the cash, please? And you look at that and you realise, my goodness me, is that if you were stood alone, and this is the test, is that if you stood alone with your team outside of the firm you are in now, would it stand up financially? And I suspect the vast majority of cases, the answer is no, because, and that's not because they're not good lawyers or good cases, it's simply because of the realities of cash flow, is that you can wait 12 and 18 months to get paid, the lockup is very long, and if you don't get it right, you'll run out of money before you get to paying salaries by month 3. So I think that's the biggest reason why people haven't replicated and kicked out and done their own practices for that reason, is that they need to be bankrolled by other departments. And that suits sometimes it doesn't, people change, but ultimately, I think that's probably the biggest challenge. For us, and the way we did it, is that we set out our stall very, very early on, in fact, from day one, that we were going to make sure that we did pay-as-you-go at a size and a limit that was significantly high. So 82% of all our work was pay-as-you-go. We do some defer, we do some contingent, but the vast majority of it was pay-as-you-go and being selected then about the cases on that basis. And that's what's worse. And in fact, that we call it the performance ratio, is the IDR performance ratio was replicated in the PE deal when we took the deal last year. And it continues to be run. It's slightly different wording, but it's the same kind of idea, is that we take on pay-as-you-go, and we have a very, very low write-off rate in terms of that. So funding alternatives, very quickly, the last two, is you can get, if you're not getting pay-as-you-go, and you've got a lot of deferred, people set up, when they first set up or when they're trying to grow teams, they want people busy. We'll take that case on, client can't afford it, we'll do a CFA as a result, and suddenly before you know it, half the caseload CFA. And then you've got some pay-as-you-go who are asking for deferred. What do you do to try and make it a little bit easier? What we do is, on our deferred, we do a percentage uplift at the end. But there are some funders, and if anybody wants some information, please do message me after this. We've got in touch with a couple of funders, one particular who will now provide funding, unsecured funding for phase 1 investigations of cases. So again, if you want that information, please just ask. Even really well-run businesses have had times where the cash flow has forced decisions. Year 5, we were approaching that stage, is that because we grew very quickly, we could see the decisions were being made because we were being defensive about finance. What if those don't come in, then what happens then? And then reining your kind of aspirations and actions. And that gets worse if you're within a firm where you're answering to other partners about the performance of your team and what you're doing, because of course they'll ask you, is that going to be billed? What about that WIP? Can't you just push that through as a bill yet? You say, look, do you want WIP or do you want age debt? How many conversations with people on this call actually had like that? And it just carries on. I mean, the beauty about IDR, I suppose, is that because we just live and breathe this, we know it, and we've got a very, very clear system that we follow. Final thing on here, very quickly, is contentious probate expertise resourcing. I think that's 2 points, really. First point is convincing your partners and the powers that be that you want to extend your team, and you'll sit there quite rightly saying, my team is burning out because they've got so much work coming through. I need somebody else. I need to hire them in. The obvious pushback you get then, and I'll allude to that in cash flow, is we can't do that because we can't fund any more money for more people coming in if you're not going to get paid for another 12 or 18 months. So you have that kind of hurdle to get over. And then once you do get over there, you've then got to find somebody. So finding contentious probate lawyers who are good quality is not that easy. There aren't many specialist teams that people have grown up and developed. The competition for hiring them is pretty strong as well. So those, I mean, you can face into all these challenges. We've done it, you can do it, but these are very real. So I mean, these are decisions that need to be made before you get started. I've got 2 more slides, very quick, I'm conscious of time. How we do it here, and I can do this very quickly because I do it every day. The big differentiator for us is we don't compete. So because we don't do non-contentious wills and probate, it means that we can work in tandem with all our referrers on disputes. They carry on representing their client. We just fix the problem or work with them to fix the problem. And then we step out and they carry on. So they never lose contact with their client. They never lose fees for representing their client. And that works very, very well. We can equally cross-refer estate administration work. So it means that if we get stuff that comes in B2C or B2C, then we can fix the problem and then pass it back to those that refer to us. Single focus of work is a big bonus as well. Data. I'm sure you do this anyway, but I can't emphasize enough how important data is for making decisions and supporting your arguments, actually, when asking for more resources, growing your teams. Is that I've got 7 years, and what it does is it helps plug the holes between biz dev and live cases being opened. What happens between those 2 points that stops it flowing as well as we can? What happens between live case and completion? Is there any way that we can minimize or shorten that length of time to reduce lockup? So we know that the estate administration market is logarithmic. I've talked about that. The target hopper, as a result, is just enormous. It's normally you get these focus funnels. Our funnel is just super wide. And what we need to then do is make sure that we go through those inquiries as quickly as sensible as we can. HubSpot upgrades, we've got a software called HubSpot. It's one of the big generic ones like Salesforce. And we use HubSpot for tracking using text. So again, from the entire journey between biz dev and completion. And we equally send out monthly referrer packs to the education piece to our referrers, and then politely sort of explain to referrers where the trends are. We tell them how many inquiries we've had. We tell them how many of those we accepted, of the ones that we didn't, why we didn't. And it's not the individual details, it's basically an explanation as to whether no loaded standard or whatever the reason is, we've got some standard ones. And then we educate. We go back and try and train so that next time those kind of referrals don't come through to us. That works quite well. IDRU is the IDR University. We bridge the expertise gap internally. So what we've done is, because of the problem of hiring in lawyers externally who don't always carry as much experience as perhaps equal people in our firm have got, is that we grow our own. So we've got a conveyor belt of paralegals that are post-grads who train with us, then do the training contracts and then qualify and go through. And that links into an internal network that we run across the firm because we're spread all over the UK. IDRM, direction travel, mediation, we've had over 1,000 cases resolved, 3 trials in that, you can work the percentage out for that. So much data that we know now about the types of mediation that we've attended, what were the determining factors, what have we learned from that? And that has all fed into what we think and hope is going to be a real help to our sector. Is a mediation service that we've now set up, and that enables people to approach us either in the traditional way of getting a mediation, we've got a dispute, we need to find a mediator, or perhaps more interesting is getting us involved earlier. Can we help out at the stage before the daggers are drawn and looking at that? So I think certainly for us, we'd like to focus a little bit more on stopping the problems occurring rather than actually solving them so much. Triage, we talked about AI is here already. We have got several tech products being released in development, save money, time, improve access to good advice for clients and the referrer. Contentious probate cases will always be managed by a legal team. I don't think anybody in this call needs to worry about contentious probate being done by robots. It's just not. It's far too personal and nuanced to be able to do it. And even if it could work it out with a decision tree, the delivery of that needs to be kept. That's equally as important as the advice itself, is how do I speak to these people? We've got 3 particular products which I think are quite interesting. The Claim Checker version 2, something we've worked with National Will Register with, that's launched on their site as well as our own, and that will provide a yes, no, maybe answer to the question, I'm not happy about this inheritance, I'm the 1 in 3, for example, what can I do about it? And it will give a yes, no, maybe answer followed by some signposts, and if it's a yes or maybe, the triage team leaps into action and gets in touch. We've also got a perceived fairness algorithm, so I'll put this out to anybody on this call to come back to me on this, is that the iDivide is the perceived fairness algorithm that effectively takes a known number of items being fought over by a known group of people, no matter what the numbers are, and it will take them through a bidding process that will then applies the perceived fairness algorithm that will divide those contents. We use it for chattels on chattel disputes with the states, divide it between the people who are competing. And bizarrely, it's a mathematical certainty, apparently. But it works. We've tested it in all kinds of groups, all kinds of people, and every time, every beneficiary feels like they've received a fair amount of the distribution, which is quite remarkable. But it gives you an idea of the directions of travel on it. And what we've also said to people is that if you don't want to be involved in dealing with contentious probate, either you're not regulated to do it, or you don't want to pay for the extra PI insurance, or you don't fancy the challenge of building one of your own, then what we do is we try and step in and just provide that additional service into your business. So we do that with CCV2, which is a claim checker version 2. That embeds in people's websites, by the way, so you can drop it in your own, you can white label it, and it pings through to us, and we can track it. And that means that we can make sure you're party to the fee share agreement that we offer those people that do it. So lots of alternatives for doing that coming through at no cost. Really interested in the lead generation space is to give back, is that because we don't have a non-contentious team, is that 2 pieces of software we've got actually not only provide a service at the front end, but actually then encourage lead generation back to the people using it. So for example, we have a piece of tech that is looking at lifetime payments. So to the bank of mum and dad, in lifetime payments, we've identified 19 different potential problems in death for lifetime payments. So we've taken what we've learned at the end, brought it back in time to the beginning, and said, how can we try and help these people avoid these claims? And what this does is it produces a solution for that, but then also makes recommendations, lead generation, to the people using this particular app at their site. So again, that's how we're harnessing tech at our end. Contentious probate, I'm under no illusion that we won't even keep up with the increase. It will continue to keep growing. I've got absolutely no doubt about that. If you want to have a go on it, by the way, play on it, just drop on either the IDRN, which is our network site, free to join, you get loads of information, or you can go onto the National Blood Register's own site, they've got it on there as well. If you just put test client, then it means at least the triage team's not going to ring you up and ask how they can help. Is if you can run through that, that will give you a report and give you a flavour of what it looks like in the hands of the recipient. So IDR Law Protect is coming. That's the sort of suite of protective bits of tech. If you register the IDRN, you'll be on the news channels for that in any event. Anybody on this call who wants to have another chat or a private chat or specific about expansion, about cross-referring if you've already got a team, or even finding insights, I'm not precious about these things, is that the market is big enough and competitive enough to enable us to work together, and I'm a huge believer in doing that. So please feel free to get in touch and contact me. I felt that was really at a pace. I am very excited and enthusiastic about what we do, so that doesn't change, but I am very conscious that I'm talking to the camera at great pace and speed and throwing things at you. Having said all that, if there are any Q&As, and conscious of time, there's only 7 minutes left, more than happy to accept any of those now, either through Philco or through the Q&A box down in the right. I'll give it a second, and if there's nothing coming through, then I'm more than happy to carry on.
So far nothing, Martin. So yeah,
that's okay. And that basically means I've either sent everybody to sleep, or I've answered everybody's question. I'm not sure either. I'm hoping neither are true, in a way. But in terms of where we go next, I think the way contentious probate's going is there's going to have to be. I mean, we've obviously got the Hirashand kind of situation at the moment where CFAs and the recovery of success fees is very much in the spotlight at the moment, and I have my own fears about that. For me, I've been around too long. I've seen the personal injury world sort of get incredibly busy and then it implode, and I think there's a little fear of that in me as well. Is that if we start going down no fee route and recovery of success fees, and then you're going to get medical reports, and then you're going to get insurance premiums, is that there's a dangerous sort of path to go down. That's just my own view. The one thing that's different, I suppose, in a way, is that unlike PI, where you're dealing with a mass of insurance companies that are pushing back, in this case, the estates don't have a group. They don't have any kind of forum or way of pushing back, and that's a bit scary, because that means that individually they're just all going to get hit, because it's the estates that will end up paying for all these success fees. So yeah, there's lots of change coming around the corner, I am sure, but I don't think human nature is going to change. You know, if you look, the Wills Act predates most of Charles Dickens' stuff, so it's not exactly new stuff, is it? And I think when you look at the Victorian times, people were living off inheritances even before parents died, you know, so none of this is new. It is the human condition, but I do think that it certainly is an area it's not going anywhere soon. I've got a question here from Nicholas. Any good contentious probate networking events for building new clients? I think it's a good question. Again, because it's a distress service, you get kind of two types of events in my humble opinion. One is where you get a group of contentious probate lawyers coming together. So there's plenty of those going around. ACTAPs hold them, there's Contra, there's local area ones. So there's plenty of that going on. So you will get to meet others there, and you can, to me, the benefit of that is sharing problems, or you might meet potential new recruits. So you know all the reasons that most people go to those kind of events. I think what you don't get is clients, of course, because they're not going to be sat there handing a card and a client's number and saying, you can have that one, I've got too many at the moment. So it's what you need to be there for is at events where there are people who will do that. Oh, by the way, I've got a problem. So you need to aim at all those B2B channels, I think, which is the sort of your will writers, your EAs, your law firms, anything that groups private client lawyers together is probably fair game, I would suggest. Right, there's a really good, there's a couple of questions here. Very quickly, Deborah, do you try and mediate or do you often go to court? 3 trials out of over 1,000 probably answers that question. Mediate would be my advice. Don't trust courts simply because they're making a binary decision very often on a singular issue looking back in time, and I much prefer to have a more rounded discussed settlement if possible. It's not always possible, as you know, but hopefully the vast majority will settle, or at least narrow the issues. Matthew, how do I deal with inquiries that lead nowhere or are solved by sending one letter that results in the person acting out of turn, suddenly doing the right thing? Do you charge for the letter as a pay-as-you-go funding? This is one of the decisions we made, is that I would view that, I mean, by all means, if it's a good case and your first letter is so good that they back off and say, fair cop, I'm out of here, then how many times does that happen? It's not very often. I think what happens more regularly is you agree to do a letter sent out, and then they don't want to come back because they don't want to pay any more fees doing it. We don't do simple letters, Matthew. We have a minimum fee, actually. So we exercise a minimum fee of £1,500 to take a matter on. And the way we do our retainers, by the way, is not old school. We do it sort of on an objective. We say to the client, what is your objective? Never mind the law, never mind about Section 50 or Section 116. What is the objective? And sometimes the objective can be, I don't want my brother or sister to get anything. And we'll actually write that out as an objective in their client care letter, because that's what they measure you against. They're not measuring you against how well you know different statutes and common law principles. They're measuring you against why they came to you in the first place. Now, don't get me wrong, we then set down, based on that objective, here are the phasing of our actions, and each phase, here are the steps that we're going to take, and each phase has got a minimum and a maximum fee estimate. So we do that. So if it's a case of we turn down anybody who simply says, can you just send me a letter and see how it goes? Either you engage us or you don't, and that's absolutely fine. And if you don't engage us, that's fine as well. So we have the luxury of lots of inquiries coming in, but we are, and it comes back to the pay-as-you-go kind of model, is absolutely no. Because if you to set up a retainer and properly advise and phase it and get out there, it's more, there's no way they will see that and think that's good value for money for that letter. They just won't, they just can't. They're seeing one letter, they're not seeing everything that goes behind it, the risk you're taking, the insurance you're providing. So we just simply say no. But it's a good question, Matthew. And Deborah, again, how often does the original will writer have to be involved? As little as possible, I think, is probably the right answer I think you want to hear, is that it depends who the will writer is and what the circumstances are. So the number of times will writers have been in witness boxes, for example, is pretty rare. I can probably count on 2 hands in the last 10 years how many times that's happened. The vast majority of them are asked questions, Larkin-Ugas requests, that type of stuff. That's really what the IDR Law Protect pack is going to be all about. But it's, yeah, most of the time, if you do the things right, you'll be absolutely fine. So short answer is rarely.
Brilliant. I think that's everything then, Martin, and we've just ticked over to 1 o'clock. So thank you so much to everyone that's joined us on today's webinar. Should there be any other questions regarding the National Will Register or anything that Martin has spoken about today, then you can see his email on screen there, and you'll also be able to contact any of the team or just reply to the webinar invite that was sent out to you, and that will come straight to me as well. So any other questions, please do let us know. Otherwise, look forward to joining you on our next expert webinar in June, which you'll see invites come through in the next couple of days.